Where'd everybody go?
All right, let's proceed.
SJC-11053, Commonwealth versus Robideau.
All right, let's proceed.
Good morning. I'd like to begin by pointing out that I made a mistake of consequence in my brief. This court did not apply the structural error analysis when discussing the so-called disappearing presumption instruction in Petita Bella. So that leaves either substantial likelihood or substantial risk of a miscarriage of justice on that instruction. And depending on how this court decides the ineffective assistance claim, it'll pick either one of those, I assume. Chief Justice Ireland, may it please the court, Aziz Safar on behalf of Joseph Robideau. This is his appeal from denial of a motion for a new trial, which he filed initially pro se with the assistance of a jailhouse lawyer, some 45 years after his convictions for first-degree murder and armed robbery. After screening the case, I entered my appearance in the trial court and filed an amended motion and supplemental memorandum stressing counsel's ineffectiveness in failing to notice an appeal. And following an evidentiary hearing, the motion judge denied the motion without making credibility findings. So this court, in essence, is in as good a position as a motion judge when evaluating the basis for his ruling. The most factually similar case on ineffective assistance is Roe versus Flores-Ortega. It's an extension of Strickland, whose test is nearly identical to Safarian's, and all of these cases postdate the defendant's conviction. I didn't find a case in Massachusetts that said Safarian may be applied retroactively, but at the same time I didn't find a case that said that it may not. But returning to Flores-Ortega, what the Supreme Court said in that case was that where a lawyer has reason to believe that his client would want to appeal, he must discuss with him the advantages and disadvantages of taking an appeal. And if his client so instructs him and the lawyer fails to appeal at that point, then he's ineffective.
And what, you probably have explained this in the brief and I should know it, but what what, if anything, is the difference between what it is that Mr. Robideau's client said or didn't say to him and what Mr. Petitabella's client, lawyer said or didn't say to him?
I think that's important, especially with regard to the absence of credibility findings in this case. At the evidentiary hearing, Mr. Robideau testified that there was an exclusive conversation between him and his attorney. And he also testified at the evidentiary hearing.
And the substance of which was?
You cannot appeal because you admitted to the crimes on the stand. It wasn't your appeal really doesn't have any merit. It wasn't that there were no issues. It was specific to his taking the stand and admitting to the offenses.
May I ask you something? Is this what the defendant says, or is this what Attorney Sheehan says?
This is what Attorney Sheehan said. Well, this is what the defendant said that Attorney Sheehan said to him. As we know, Attorney Sheehan's now deceased.
So he's,
I couldn't call him, yes.
right, okay. So that's the defendant's report.
And in Petitabella, what was the evidence?
The evidence was similar, but it wasn't so much in terms of a directive that you cannot appeal. In other words, in Petitabella, there may have been more of this dynamic where there was a discussion, where this was more of a directive. You took the stand and admitted to the crimes, therefore you cannot appeal. And understanding Mr. Robideau's situation, I mean, Mr. Robideau, in terms of his knowledge of the law, the record bears out that he has a very simple understanding of the law, and I don't mean that in a condescending way on behalf of my client. But he took the stand and he said that Attorney Sheehan also, almost in a conclusory fashion, told him that he could not appeal because he took the stand.
Well, the judge doesn't have to believe that.
We don't know either way whether he did or he didn't. I mean, if
Okay, so you're saying it's now in our lap.
yes.
We don't have to believe that.
Well, but if we look at the record, I suggest it's reasonable to conclude that Attorney Sheehan had a reasonable belief that there were appealable issues. He took what were called then appellate exceptions, several appellate exceptions, including the exceptions to the insanity instructions, which the judge combined Rogers and McCann. And there was also the defendant was entitled to review for a reduction of his guilt, which would, by virtue, impact this sentence. So to say that there's no merit at all in appealing, just because.
Well, it would have been exposed him to the death penalty again.
Well, I'm sorry. What would
If he appealed and got a new trial,
right?
And if his conviction had been appeal, new trial, he's at the new trial stage again. He is now re-exposed to the death penalty.
I'm with you in agreement, Justice Spina, if the only remedy available were a new trial. But he also, at that time, he also had available to him 33E review, whereby he could limit his prayer for relief to a reduction of his verdict because of the nature of this case. He was eligible for that. And if this court then says, well, you're not bound to the particular prayer of relief that the defendant makes, but guided by the law of the times, it should also consider that if the court finds that his trial attorney had no real basis for an appeal in connection with a retrial situation, then this more so becomes important that he was eligible for an examination for a reduction of verdict. So a new trial was not the only remedy that was available. And I pointed that out in the response brief.
Would the appeal have only included a request for relief under 33E, only a reduction of the degree of guilt, or would it have also included a request for a new trial?
It could have included both.
I mean, didn't you say that that Mr. Sheehan objected to the shackles, for example? I mean, there were
Correct.
issues that would seem to form the basis of a motion for new trial.
That's exactly right. But I'm also arguing alternatively, if the court says, well, those issues from the get-go had no merit and would not have gotten the defendant anywhere. And I guess what I'm saying is what we have to look at is not so much whether the issues are viable now, as much as how they bore on the attorney's mind at the time when he advised or when he gave that directive to Mr. Robideau.
Okay, so was it manifestly unreasonable at that time for the attorney to recommend or to say you should not appeal?
Yes, because I'm following the analysis and I'm looking at what this court said in Petita Bella, that essentially there's the risk of retrial, and with that risk there's a risk of the death penalty because the controlling precedent at the time was Stroud. But he also had eligible to him a reduction in sentence, a reduction in verdict, which would impact his sentence.
Well, that's why I asked you that question. Really, in order to eliminate the risk of exposure to the death penalty again, wouldn't he only be able to request a reduction in sentence?
Yes, if the other issues.
Well, what if he wins on the other?
If he could win on the other issues, I mean.
Then he gets the new trial.
That's the other. That's the other problem. Not only did Attorney Sheehan not properly consult, as the Flores-Ortega case requires, but his advice, his directive, was an inaccurate statement about the law of the case. Merely taking the stand and admitting guilt doesn't obviate all the defenses. He still had intoxication, and he still had insanity defenses, and of course he still had review for 33E reduction of the verdict. So not only was there no consultation, but it was also a misrepresentation of the law. And Flores-Ortega goes on to say that under these circumstances, the defendant is not required to show that there was prejudice or which, if any, of the issues had merit. What he needs to show is that his attorney's erroneous behavior was the proximate cause of his failing to take an appeal. And I think that was met here. If we look at the record, and I think that was met. I mean, we focused our argument on this.
Shouldn't we take into account that this is coming 44 years later? And how to reconstruct a record? The lawyer is passed away.
Yeah, he's been incarcerated during this whole time. I mean, I don't know that it's so much a benefit to him. He's been incarcerated.
I'm not saying it's a benefit to him, but the interest of finality and the interest of deciding issues in a timely fashion. He just woke up and said, "Oh my God, my attorney told me directed me to not appeal."
I think what had happened was he luckily got in touch with somebody who knew a little bit about the law. It was a jailhouse lawyer who wrote a motion for co-defendant Sousa and contacted the other two defendants, and he basically assisted him, and then he raised these issues.
What happened with Sousa?
Sousa's deceased.
But Sousa was affirmed
I'm sorry. Yes, Sousa was affirmed.
in 1966.
Yes.
No, but this was a motion for new trial on Sousa that you were talking about, right?
Yeah, I think he passed on before the court had an opportunity to hear the motion. But again, that exemplifies simply because. Sousa, simply because there was a death penalty, that Sousa took the appeal. The only difference was when he testified, he didn't admit to the elements of the government's case. Are there any other questions with this? Like I said, I want to focus our argument on this ineffective assistance. I do think that the standard should be Flores-Ortega that should apply to this case. Anything else?
Thank you.
I'm sorry, one more question. Going back to the fact that the judge here essentially adopted his findings in Petabella, which of course don't help us to figure out what was said between Robideau's attorney and he, what do we do? Do we just make our own findings, even though we weren't there to see the testimony of Robideau? Do we send it back? What should we do?
I suppose if the court concludes that the record is insufficient to flesh out what the dynamics were, then it should be remanded for findings.
Thank you, sir.
May it please the court, Tara Blackman for the Commonwealth. I want to start from the standpoint that first, all of these issues have essentially been resolved by Commonwealth versus Petabella. The only difference in this case from Petabella, the only way it stands in different footing, is that the motion judge in Petabella did make credibility findings with respect to Petabella's hearing testimony, and here the motion judge did not do that with Robideau. But in Petabella, with regard to Petabella's motion, the motion judge found that regardless, even if he credited Petabella's testimony, regardless, all of the issues that the defendant raised failed as a matter of law. And similarly, that is the case here. All of Robideau's claims fail as a matter of law. First of all, his claims are basically the same as what Petabella made, that he could not appeal, and also in his affidavit, he did say that his attorney told him that an appeal would be meritless, and that was in Robideau's affidavit also. But regardless, even if his testimony at the motion hearing was credited, still, Attorney Sheehan's representation and his advice to him not to appeal, or that an appeal would be meritless, was not unreasonable given the circumstances.
What was the difference in the verb that the lawyer used in Petabella and the lawyer used here in Robideau concerning whether or not there should be an appeal? Did he say you cannot appeal in Robideau? You cannot appeal in Petabella?
I think he said, I think in Petitbella, I think it was the claim that it was, he said cannot appeal, and here it was also the claim could not appeal. I think here also, I think in Petitbella, it was also the claim that his defense counsel told him that it wouldn't have any merit in appeal. And here again, in his affidavit, Robideau said, not at the hearing itself, but in his affidavit, Robideau said that Attorney Sheehan advised him that an appeal would be, in quotes, meritless. So, I think it was
and in
pretty
Petitbella,
much-
there was a factual credibility or a factual determination made as to what the lawyer advised?
yes, there was.
And what was that?
In Petitbella, the motion judge said that I don't credit Petitbella's testimony and his assertions that his attorney told him that he couldn't appeal. I think he discussed it with him, and that they discussed it. He explained to him that an appeal would be pretty much meritless, and then based on that consultation, attorney Petitbella took his attorney's advice and
We don't
proceeded
have that
way.
here.
We do not have that here, no. So what we have to look at is, regardless of those credibility findings, whether Robideau's claim fails as a matter of law. First of all, I start from the position that it's the Commonwealth's position in this case that the Lucier standard is the standard that should be applied, because we should not be applying an ineffective assistance standard that was 10 years after, decided 10 years approximately after the defendant's trial. And under the Lucier standard, what we look to is whether counsel's representation amounted to a farce or a mockery of justice. And clearly, that was not...
And that's the standard we should be applying?
That's the Commonwealth's position, that is the standard. The Commonwealth's position is that regardless whether we apply that standard or whether we apply the standard under Safarian and Strickland with the Rose v. Flores-Ortega consultation requirement, that regardless the Commonwealth prevails, but that the Commonwealth's position is that the Lucier standard is the standard that should be applied in this case, because that was the standard that was at the time of the defendant's trial.
You really think that you think that we would, if we found that it failed Safarian and met Lucier, we would say no relief here?
It's the Commonwealth's position that that's the standard that should be applied, because that was the standard at the time of the defendant's trial. And how can a defendant's representation be measured at a standard that was not the standard at the time of the defendant's trial? That wouldn't really be consistent with what even this court has, even what has been announced in Safarian, which is at the time of. We look at the reasonableness of the defense counsel's actions at the time of the defendant's trial. But regardless, even if we apply the Safarian Strickland Rose v. Ortega analysis, the defendant still fails because.
Now, I'm sorry. Has the court ever ruled, this court or the U.S. Supreme Court, as to whether Strickland or Safarian are retroactive or not?
It is not clear. No. No, it is not clear, no. So we're left, that would be for this court to determine if it was to apply Lucier or in Petitbella, this court did apply the Strickland-Safarian standard, but the reason it did that is because it said it doesn't even need to determine that. It doesn't even need to make that determination, because here, basically, no matter what, it fails under Strickland-Safarian and Rose v. Flores-Ortega. And it's the Commonwealth's position that regardless of the judge's credibility findings in this case, it still fails under Rose v. Flores-Ortega. And that is because, first of all, we have Rose versus Flores-Ortega, and that consultation requirement only triggers in two circumstances. One, that the defendant has made clear to his counsel that he wants to appeal, which, according to even the defendant's own assertions in his affidavit and his motion hearing, he never makes that claim. And then there's whether an irrational defendant in the defendant's position would want to appeal in the circumstances.
Now, I'm looking at the affidavit of Mr. Robideau.
Yes.
In support of his motion. And he says, it's a very short affidavit. Number one, I am the defendant in the above captioned matter. Number two, following my trial attorney at the time told me that any direct appeal on my behalf would be meritless because I took the stand at my trial. Paragraph number 3, I relied on his representations as I am unfamiliar with all the relevant laws that pertain to my case. Paragraph number 4, but for my trial attorney's representation that I could not appeal, I should have taken an appeal. I would have taken an appeal. And then it's signed under the pains and penalties of perjury. That last item, number 4, says, but for my attorney's representation that I could not appeal, doesn't quite jibe with what he says above, that his attorney told him that any direct appeal would be meritless.
I would agree with you, Your Honor. I would agree that there were certain inconsistencies.
So in number 4, how do we read that? Is that intended to be a representation of the attorney's advice, or is it the defendant's interpretation of the defendant's of his attorney's advice?
I think that it is. I think, honestly, it's a representation of his credibility, and that he is saying that his attorney, at one point he's saying that his attorney basically advised him that it would be meritless, and then in 2 sentences down, he's saying that his attorney told him that he could not take an appeal. I don't know how to read that precisely. I think that he's basically saying that his attorney told him he could not. He doesn't put it in quotes. So it's hard to determine. Again, the judge did not make credibility findings. I would say that there were certainly enough inconsistencies within the affidavit itself, and with according to his motion hearing testimony for the motion judge to find that he was not credible. The motion judge did not explicitly find that, however. So then we're left with, does his claim fail as a matter of law? And as a matter of law, it does, because as this court has recognized in Petitbella and today even, that we have to look at it from a rational defendant's standpoint, in the defendant's position. This is a defendant who had committed a heinous crime, first-degree felony murder. A jury had found him guilty of that. He had gotten on the stand against his counsel's advice by his own admission to, 1, exonerate his fellow co-defendant Souza, and 2, he had fully confessed to the murder. So this was a case where at any future trial, that confession would have been used against him. On a new trial at the time, as this court recognized in Petitbella, he would have been subject to the death penalty. In those circumstances, this was essentially a win for the defendant, avoiding the death penalty based on the facts that were presented at trial. Had he appealed, he would have been subject to the possibility, had the court found that there were any meritorious issues and he was granted a new trial, he would have been subject to the possibility of the death penalty. Now, I know my brother talks about 278-33E review and how the defendant could have opted for just a lesser verdict. I think that a 278-33 review, had this court determined there were any meritorious issues, it would have been the court's determination whether to find the proper remedy that was consonant with justice. And that, had the court found a new trial was the proper remedy, again, he would have been subject to the possibility of a death penalty. And I think in these circumstances, given the defendant's confession at trial, given the facts of this case, it was entirely reasonable. Not only reasonable, but it was reasonable for the counsel to think that no rational defendant in the defendant's position, having taken the stand, would want to appeal his case. Therefore, whatever standard we use in this case, and whether we even assume that his testimony hearing was credited, which I don't think this court should assume that, of course, because the judge did not make any credibility findings. But even if we were to take that as true, regardless, his claim fails as a matter of law. Now, also, the defendant raises 2 other issues. Because, first of all, Commonwealth's position is certainly that it was not ineffective assistance not to proceed with an appeal. The defendant does not benefit from 278-33 review. Rather, this is a collateral attack upon a conviction. And therefore, with respect to his other claims, the standard for this court to use would be it's the Commonwealth's position, substantial risk of a miscarriage of justice. With respect to the presumption of error instruction claim, I feel that this issue has already been fully resolved by Petitbella. In Petitbella, the court found that it was not a structural error, and also that based on the entirety of the instructions, it was very clear to the jury the Commonwealth's burden of proof. And that is what we look to, whether or not it was clear that the Commonwealth had to prove every element beyond a reasonable doubt. So I think that matter has been fully resolved. Also, the defendant's claim about him being in shackles, regardless of whether or not DEC versus Missouri is retroactive or not. This court determined in Petitbella that regardless, it doesn't matter because it was within the judge's discretion. But the rule in DEC is not absolute. And it's a question of, it's a matter, still within a matter of judge's discretion whether or not shackles are appropriate. And given the execution type of killing in Petitibella's case, it certainly was warranted for the defendant to be in shackles. I know my brother argues in his brief that the defendant's stand had stood on some different footing than Petitbella because he was not the one who pulled the trigger. I would say that that argument is extremely unpersuasive given the facts of this case. Yes, Robideau was not the one to pull the trigger, but he acted in concert with Petitbella. It was clear that he planned the entire thing. He was holding the women in the front of the bar at knife point while he heard the shots going off. And when one of the victims became hysterical, he hit her right after he heard the gun go off, and the victim, which was the result of the victim's death. It is, of course, the Commonwealth's position that DEC should not be retroactive, considering it was decided over 40 years after the defendant's conviction. But regardless, it's the Commonwealth's position that the claim still fails. If there are no further questions, I'll rest my brief for the remaining.
All right, thank you.
Counsel.
All rise.